Okay, good day to everyone. So our topic for today is about criminal evidence. Okay, evidence is very important, especially for you, future law enforcement officers. Okay, so you will be uh, encountering numerous evidence. Okay, but importantly, you must know what is the concept of evidence, no? Dapat malaman mo muna ano ba ang ibig sabihin ng evidence, no? So, kasi sa inyong, career as law enforcement officers, no, puwede kayong ipatawag sa hukuman para, ah, malaman, no, para malaman ng hukuman kung kayo ang magwi-witness sa isang, kaso. For example, kayo ang nagkalap ng ebidensya sa isang crime scene, no? Kayo ang tatanungin ng hukuman upang mapatunayan, no, na ito nga mga objects na nakalap ninyo ay present doon sa crime scene. Okay, so under your general principles, ang concept of evidence, no, these are the means sanctioned by these rules. Ano yung these rules na tinutukoy rito? These are the rules of courts, okay? Of ascertaining in a judicial proceeding the truth respecting a matter of fact. So yung truth is not necessarily the actual truth but one referred to as the judicial or legal truth. So, ah, sinasabi rito class na ang evidence, no? Ang evidence is ito yung pinapayagan lamang ng ating rules of court upang patunayan mo sa hukuman, no? Ang isang katotohanan, no? Ang isang katotohanan na ah, respecting a matter of fact. Okay? So, hindi kailangan na yung actual truth ang mapatunayan, no? Ang sinasabi lang rito ay yung judicial o yung legal truth. So, anong scope at applicability ng rules of evidence? So, yung scope and applicability of rules of evidence, so sabi rito, under the rules of court, the rules of evidence are specifically applicable only to judicial proceedings. So, ang ating rules of court class, lalong-lalo na ang ating rules of evidence, no, applicable lamang ito class sa ating hukuman. Ang rules of evidence hindi yan applicable sa barangay hearing, hindi yan applicable sa pag ikaw ay tinatawag sa barangay, hindi applicable ang ating rules of evidence pag tinatawag ka sa isang investigasyon sa paaralan o kaya sa anumang ahensya ng gobyerno, hindi mo pwedeng gamitin o i-apply ang rules of evidence. Kasi sabi rito, ang rules of evidence lamang ay applicable sa mga judicial proceedings o kaya yung mga hearing sa mga hukuman. So, under your judicial proceeding, there are three kinds only. So, we have the civil action, which is of two kinds, ordinary civil action and special civil action. Number two, criminal action. And number three, special proceeding. So note that all other proceedings are non-judicial. Hence, application of the rules of evidence in the rules of court is not mandatory unless provided to be so by law or regulation. So let's differentiate proof from evidence. So proof, these are the result or effect of evidence. And evidence, these are the mode and manner of proving competent facts in judicial proceedings. Factum probans and factum probandum. Factum probans, these are evidentiary facts, or these are facts by which the factum probandum is to be established. Materials evidencing the proposition. Factum probandum, these are ultimate facts or facts sought to be established, or these are the proposition. How about admissibility of evidence? These are evidence admissible when it is relevant to the issue and not excluded by the Constitution, the law or these rules. Admissibility of evidence refers to the question of whether or not the circumstance or evidence is to be considered at all. On the other hand, the probative value of evidence refers to the question of whether or not it proves an issue. So what are the requisites for admissibility? So the requisites for admissibility is that it must be relevant to the issue. And next, it must be competent. Pag sinabi natin competent, it must not be excluded by the Constitution, the law, or the rules of court. When we say relevant, it is when the evidence has such a relation to the fact in issue as to induce belief in its existence or non-existence. When we say competent, it must not be excluded by the Constitution, the law, or the rules. So the importance of offer in relation to admissibility parties are required to inform the courts of the purpose of introducing the respective exhibits to assist the latter in ruling on their admissibility in case an objection thereto is made. So all evidence must be offered orally. So offer of testimonial evidence, it must be made at the time the witness is called to testify. And letter B, the offer of documentary and object evidence, it must be made after the presentation of a party's testimonial evidence. Okay, so tignan natin the relevance of evidence and collateral matters. Relevancy, when the evidence is relevant, when it has such a relation to the fact in issue as to induce belief in its existence or non-existence. Dapat konektado yung evidence as to the age of a person who has been raped. So evidence is relevant in a situation where the age would qualify the offense to statutory as to induce belief in its existence. It must be determinable by the rules of logic and human experience. Collateral matters, these are matters other than the fact in issue and which are offered as a basis for inference as to the existence or non-existence of the facts in determinable by the rules of logic. So the general rule, evidence on collateral matters is not allowed except when it tends in any reasonable degree and which are to establish the probability or improbability of the fact in issue. General rule, evidence on collateral matters is not allowed, except when it tends in any reasonable degree to establish the probability or improbability of the fact in issue. So for your activity, no, ito ay isang paired activity. Bahala kayo kung sino gusto niyo maging partner, sino gusto niyo maging kabady, ha? Basta ito ay isang paired activity. Write your answers in yellow paper, ha? Yellow paper, wag coupon ban, wag bond paper. Yellow paper. Your answer and answer the following questions, ha? So in not less than 50 words, answer what is the importance of studying evidence as a criminology student? Okay, in not less than 50 words. So letter B, in Tagalog, ha? In Tagalog, differentiate proof from evidence. Again, this question must be answered in not less than 50 words. Okay? Alright, class, that's all for today. See you again next meeting.